I would conversely ask you to consider dismissing the case under 1611-440 with C specifically, which is South Carolina Stand Your Ground law. If in fact, and if you look at the state's evidence, if in fact you take their evidence and say that my client is in the road and fires a weapon at Mr. Williams, and that is the fatal shot, as they are attempting to say, he is in a vehicle that is leaving the scene when Mr. Williams follows them, chases him through town, and at some point fires the first shots in this incident, according to the statements that are given in this case. As they come back around, he says, "Let me out of the car." Now the state tries to purport that as saying he pulls open the car and jumps out of some vehicle running at 70 miles an hour, yet he's got an injury to one finger and I think a scrape on his elbow. That doesn't seem indicative of somebody who leapt out of a car at that speed. So he could have been someone who simply wanted to get out. He sees the vehicle coming down the road. Every testimony is that Mr. Williams pursued the truck even after they had turned on the road. My client would have every right at that point to defend himself, and I would ask you to dismiss under 1611-440C.
With regard to Mr. Frick's argument under 1611-440C, the first sentence in that is a person who is not engaged in unlawful activity and is attacked in another place where they have the right to be. First of all, Mr. Moore did not start out in the road. He started out in the truck and elected to get out into the road. He was engaged in unlawful activity, and I don't know that, I understand the concept of what he was intended to do in terms of the armed robbery doesn't necessarily carry over to the murder. However, he was not engaged in unlawful, he didn't have clean hands when the whole thing started. He was engaged in unlawful activity. He had gone over, armed himself to go over and attempt to, according to the co-defendant's statement, rob an adjacent house, or house that, they obviously driven over there with the intent to rob a house that they could walk through a path to get to. And so he was not clean-handed when he started to submit that 1611-440C does not apply to him.
With regard to outright dismissal for lack of probable cause, there is some evidence that would tend to support the underlying charge, and there is reason to believe that this charge has some validity to it. The defendant did in fact commit the offense with which he is charged. With regard to the Stand Your Ground law, as it is called, we're really talking about the Castle Doctrine. I am not convinced that the Castle Doctrine would bar prosecution in this case, besides which I don't think that that is really all that proper for me to rule upon anyway, but should be viewed by a circuit court judge as potentially a motion in limine or a motion during trial at the election of the defense. Therefore, dismissal on that basis is inappropriate.